Good afternoon, ladies and gentlemen, and welcome to today's part of our Restarting Business Practical Guidance series. Today we're going to be looking at commercial property considerations. My name's Colin Smith. I'm just doing the hosting duties today, and I'll be handing over very shortly to Charlotte Laherty from Caxton's, who's going to take you through various commercial property aspects of the current situation. And then she's going to hand on smoothly and seamlessly, we hope, to James Millis, who you can see them all on camera here laughing because we've just been testing how well that goes, so we'll see how it goes today. But she will hand on seamlessly to James, who will then take us through some of the legal aspects of where we are in commercial property considerations. Before I waffle on any further, for anyone who's been on any of our sessions before, you'll know what's coming next, but if any of you do know how, metaphorically, to put your hand up using the system or to type into a questions box a question just to let you know, rather just to let us know that you can hear us, that would be fantastic so that we know we're not talking to ourselves for the next half an hour. Good, I can see at least a couple of people have done that, so great, hopefully you can all hear us. Second point is, obviously, some of you will have just discovered that there is a question submission facility. It's a question mark or a question mark symbol somewhere on the software that you've got, depending on how you're logging in today. So do please, as you go along, if you've got questions you want to put to our speakers today at the end of the session, type them in as we go along or type them in at the end, and we will obviously then hopefully collate them all at the end and try and answer the ones that we're able to do so. Okay, I think the idea is that the speakers will be speaking for about 40 minutes today, and then there'll be some time at the end for questions should we need it. Okay, so I will stop waffling on and getting in the way. I will hand over to, as I say, the first of our two speakers today, Charlotte, who is going to take you through some of the commercial property implications. So if you can give us 10 seconds to hopefully hand over to Charlotte, and then she will be with you to take it from here. Thank you. I can just let you know, Charlotte, I can see all the slides. That's all fine.
Thank you. Thanks, Colin. Hi, afternoon, everyone. I'm Charlotte Laherty, as Colin said earlier. I'm impressed that he's pronounced my name correctly. We were just discussing that, so well done, Colin. I work for Caxton's Chartered Surveyors and Property Agents. I'm director responsible for the Commercial Property Management Department there, and we act primarily for investor landlords, overseeing the management of a diverse range of commercial properties. This includes about 1,300 business tenancies in all, operating within the retail, hospitality, leisure, office and industrial sectors, and they're predominantly based in Kent, but we do cover the wider South East area too. I'm going to talk to you today about the UK government's new code of practice for commercial property relationships during the during the COVID-19 pandemic. And to give you some background on that, I'll take you back to early to mid-March, when some tenant companies were starting to see business slow down already at that point, and those particularly affected relied on elderly customers or were located in areas where there was a largely older demographic. At that point, this group of people had started becoming quite nervous about going out, and we saw some tenants struggling very early on, with sales falling even before lockdown was imposed. The government then closed down the entertainment, hospitality and indoor leisure sector on the 20th of March, and non-essential retail closed a few days thereafter. The standard call to rent day for commercial property fell due 5 days later on the 25th of March. With many businesses forced to close, as a managing agent, we became rather inundated with requests from tenants for rent concessions, deferrals, holidays, etc. Many tenants sought to agree mutually satisfactory payment plans with their landlords or move towards monthly payments to assist with cash flow. A significant number of predominantly large corporate tenants, however, simply failed to pay the quarterly rent at all. Some landlords were supportive, others not so much. The graph on the screen shows the impact of this on rent collection levels, with just 47% of rent across the sector having been collected 1 week after the quarter day, with retail having been the most severely hit. Another report by Remit Consulting suggested that 21 days after the March rent quarter day, 67% of rent and 56% of service charges had been paid, based on their ongoing survey of about 18,000 properties. So the figures improve over the course of the quarter, with many tenants having been late to pay or having reached agreements to pay in instalments. At this stage, it became clear quite quickly that with income streams having been essentially cut off, a lot of businesses would genuinely not be able to afford to pay the quarterly rent and could be subjected to aggressive rent collection tactics by their landlords. In a bid to safeguard those tenants who were genuinely suffering as a result of the lockdown measures, the government introduced protection by way of a moratorium on forfeiture proceedings in the Coronavirus Act 2020. And there's an extract of that on the screen, which says the Act ensures leases can't be forfeited for non-payment of rent for a 3-month period for all types of commercial tenants, but still allows for forfeiture at the end of the period for such non-payment. And this works to encourage businesses that are in a position to make their rent payment to do so, whilst providing 3 months grace to those that are struggling. So effectively, landlords couldn't seek possession or even threaten it as a means to collect rents until the 30th of June. The main issue was that there was still a large proportion of tenants who probably did have the means to pay at least some, if not all, of their quarterly rent, and at that point in time, failed to do so with the protection of the moratorium. But there were, of course, undoubtedly a number of landlords seeking to pursue those who potentially could not meet their liabilities, and the next possible remedy was an order for winding up. You may have heard of the Travelodge case, along with some other high street names such as Boots and Matalan, Pound Stretcher, etc., being discussed in the press quite a lot recently. And these were tenants who declined to pay rents on some or all of their premises, but many felt this was unjustified when these big companies had traded so successfully up until this point. They had strong balance sheets, and by now the government had also announced a whole raft of financial support measures to assist them. Some had even been able to remain open and trading under the essential retail category, albeit income in some cases had undoubtedly reduced with lower levels of footfall generally. Nonetheless, the government could clearly foresee a surge in statutory demands, given this was now one of the few remedies left available for landlords, and consequently on the 23rd of April they announced that the use of stat demands and winding up petitions would be restricted to safeguard the UK high street against aggressive debt recovery actions during the pandemic. Whilst the strapline to the measures refer to the UK high street, the provisions to implement them, which are included in the Corporate Insolvency and Governance Bill, are not sector specific and apply to any registered or unregistered company that can be the subject of a winding up petition. The restrictions apply for a period from the 27th of April to the 30th of June, but have now been extended along with a moratorium on forfeiture proceedings until the end of September. The final nail in the coffin for landlords was plans to pursue tenants who failed to pay rent came in the suspension on the use of enforcement agents. The taking control of goods and certification of enforcement agents regulations prevented landlords from using this remedy unless an amount of at least 90 days rent was due, when it had previously been 7 days rent. From the 24th of June, this was increased to at least 189 days rent, and the restriction also now applies until the end of September or such later date as may be specified in the regulations. So as it stands, we've got landlords' remedies for rent collection now substantially limited, and still a large number of tenants who cannot meet their rental obligations under the lease. The government's answer to this is the new code of practice for commercial property relationships during the COVID-19 pandemic, endorsed by a number of industry bodies, including the British Chamber of Commerce, the Royal Institution of Chartered Surveyors, and the British Property Federation, among others. The code was introduced on the 19th of June, which was just days before the next quarter rent day on the 24th. It makes it clear that the restrictions on the recovery of rent are exceptional but time limited and exist to provide tenants with breathing space to work with their landlords towards a sustainable future. The code, they hope, will encourage best practice, mutually beneficial agreements to become common practice. But an important point to note is that this is a voluntary code and it does not alter the underlying legal relationship or lease contract between the landlord and the tenant and any guarantor. The code encourages tenants who can pay to pay rent in full. It encourages them to do that, but does say that tenants who are unable to pay should seek agreement with their landlord to pay what they can. It encourages landlords to consider a reasonable case put forward by a tenant in distress and provide support to tenants where possible while having regard to their own financial commitments. The code does make it clear that government support provided was done so on the basis it was used to sustain the business and meet costs, one of these of course being rent. The code applies to all business leases in all sectors and to any organisation negatively impacted by the crisis. Both parties should consider the long-term viability of the business and consider negotiating or renegotiating rent to ensure the continuation of viable businesses where possible. The code has 4 main principles, which you can see on the screen: of transparency, a unified approach, government support, and acting reasonably and responsibly. And transparency talks about the need for landlords and tenants to act reasonably, swiftly, transparently, and in good faith. It encourages parties to act like economic partners, not opponents, with a mutual interest in business continuity. A unified approach urges the parties to collaborate and support each other. And the third principle recognises that government support for businesses has been provided to help them meet their commitments, including supplies of goods and services, and also rent, utility costs, insurance, etc. The final principle doesn't really need much elaboration. It just reminds us to act reasonably and responsibly. The code goes on to say that third-party mediators are encouraged where an agreement cannot be reached between the parties. But it also states that tenants seeking concessions should be clear with their landlords about why this is needed, including being prepared to provide financial information about their business. Landlords seeking to refuse concessions should be clear with tenants why they cannot agree them, accompanied by a reasonable explanation. And landlords should have consideration to various factors when considering support for their tenant, including the duration of the closure period, the extra costs incurred by the tenant in protecting customers and staff, and the need of other stakeholders, such as banks, employees, and suppliers. The landlord should also consider the government support that the tenant may have received and how it has been used, including the tenant's previous track record in relation to rent payments, amongst other factors. The code gives some quite useful suggestions for agreements. There's some on the screen which you can see, but just to quickly summarise: moving to monthly payments instead of quarterly, or paying in arrears, which will help with cash flow in some cases. Turnover rents are suggested, along with rental variations to reflect the current market. Rent reductions, or landlords drawing from rent deposits held on account. Landlords waiving default interest on arrears, which is payable in most cases under leases and usually around 4% plus base mark. And splitting the cost of the rent for the closed period between the landlord and the tenant. The code also suggests reaching agreements for reversionary leases or removal of break rights or extensions to leases in return for some of these concessions, so that there's something being given back to the landlord, perhaps, in return for a concession agreed. The code has got a small section on service charges, but it does encourage tenants to pay these in full to ensure that the buildings continue to be insured and maintained. And it does also acknowledge that extra costs may actually have to be incurred now to ensure that these buildings are COVID compliant. So things like risk assessments we're having to undertake on common areas, extra cleaning, for example, that's all going to push the cost of the service charge up, certainly in the short to medium term. It does, however, say that landlords should continue to ensure that service costs are reduced where possible and that they're providing best value for occupiers, and that any reductions or savings on the service charges while the buildings have been empty should ideally be passed on to tenants at the earliest opportunity, rather than waiting for the year-end reconciliation to take place. So where we have a lot of office buildings that have been empty for a number of months, there might be reduced services, for example, heating and lighting. Cleaning costs may have even been ceased during the closed period, and those savings potentially should be passed on sooner rather than later. The graph on the screen shows the impact that all of this has had on rent collection levels for the June quarter rent day, which fell recently, and compares it with March. And as you can see, the numbers are largely the same, which in some respects is very positive, given that many people anticipated it would be much lower based on a large number of businesses having had no income at all for the past 3 months. So that's quite a promising sign, at least. In our experience, landlords and tenants were largely adhering to this code before it was even thought up, and I have no doubt that the market was the driver behind the principles of it. I think it's testament to the adaptability of the property industry that many parties were seeking to work together to overcome the crisis and support one another through this time. We witnessed a great number of tenants making reasonable requests for monthly payment plans, and even those in arrears committing to pay all of the outstanding sums over an extended but agreed period. On the whole, very few rent-free periods have been sought or granted, as largely tenants want to be able to meet their lease commitments and just need the flexibility afforded by most landlords to assist their cash flow in the short term. Where a tenant has demonstrated a concession, such as a rent-free period or a reduction, would help sustain their business in the longer term, most of our clients have been quite supportive. But this really has been the exception rather than the rule, and we continue to see repayment plans agreed. In some limited cases, a small rent-free period has been agreed in return for the tenant relinquishing their break clause, extending their lease, or agreeing to take a reversionary lease. And it was recently reported in the press that Monsoon Accessorize, the high street retailer, they're planning to keep 57 more stores open than initially planned after a raft of landlords agreed to new turnover-based rents. So there will potentially be a move towards this kind of lease structure going forwards. Some of the larger tenants have unfortunately frustrated the situation slightly by taking extended periods to come up with proposals. So Travelodge is a well-documented case, but unfortunately this is a reflection of the issue more generally, with most of the larger companies we deal with having taken almost the whole 3-month period to approach us to discuss the matter and reach agreement. And this has not really helped their case, because whilst undoubtedly they have the unenviable task of reviewing significant portfolios and sites across the country, these delays in coming to the table have in some cases put serious strain on landlords' ability to meet their own commitments in the meantime. When proposals have eventually been made, in most cases they are reasonable, but in some cases they're completely unreasonable and would compromise the landlord's ability to support other tenants, and in some cases those in more desperate need. On the negative side, there are unquestionably tenants who've taken advantage of the landlord's inability to pursue them for the arrears, and the key is distinguishing between those choosing not to pay and those which are truly unable to do so. Furthermore, the code has come under criticism as being toothless all the time landlords have no other remedies available to them, as the tenant can effectively ignore the code without fear of real sanction. It's also been criticised by landlords that while the code demonstrates the ways in which the crisis has impacted tenants' businesses, it doesn't demonstrate the ways in which a tenant's failure to pay the rent can have a financial impact on the landlord. Some have claimed it fails to overcome the imbalance between landlords and tenants' respective negotiating positions, when on the one hand, the government has legislated against landlords, yet tenants are only subject to a voluntary code. Anecdotal evidence suggests that landlords have largely been willing to engage with and support tenants who have been honest and transparent. The voluntary nature of the code may not be particularly useful when dealing with so-called rogue, larger and well-capitalised tenants who continue to ignore clear government advice to pay rent when they can and they should. Any change in their behaviour would really rely solely on their moral compass rather than imposed on them by law. So it remains to be seen what will happen after the 30th of September, but watch this space. Thank you very much. And if you've got any questions, no doubt Colin will go to those at the end.
Yes, obviously, as we said earlier, if you do have questions as we go along, do please type them in, and obviously we'll try and pick them up at the end. I'm conscious people have these questions and then forget them if they don't chuck them in while they're thinking about it. Thank you for that, Charlotte. I will hand over now to James Millis, who is one of my colleagues and a partner dealing with commercial property disputes. So if you bear with me 2 seconds, I will hand over control of what we're doing to James. Marvellous. I can see your slides, James, so away you go.
Excellent. Hopefully you can hear me as well. Thank you, Charlotte, for running through that and referring to the code, and also setting out very well the background to the circumstances which have led up to the code of practice. So you've heard about the sort of sensible and reasonable proposals envisaged by the code, which is that the parties should act in accordance with the code and try and reach agreement. I'm going to address really what if the landlord and tenant are unable to agree terms. As Charlotte's mentioned, part of the issue about the code is whether it's toothless without any real sanction in place for tenants. So we'll look at what if terms can't be agreed, how those enforcement remedies for a landlord are affected by the code, the COVID-19 legislation in its various forms and changes in practice and practice directions, etc. And again, a little bit of thought really about what might happen after the 30th of September. I thought I'd start by commenting on what the government said in its press release of the 23rd of April, that landlords are urged to give their tenants the breathing space needed, and the government calls on tenants to pay rent where they can afford it or what they can, in recognition of the strains felt by commercial landlords too. And that of course, is what Charlotte has referred to in their experience of most reasonable people agreeing terms. But of course, it does require people to agree reasonable terms, and as some of the news stories from the press do tell, not all tenants are being reasonable in what they're doing or paying when they can, in exactly the same way that there are some landlords who might not be reasonably accommodating the tenants' requests. So in relation to the code, it is a voluntary code. It logically sets out a new best practice guidance for the landlord and tenant relationship for all those points which have been referred to. Interestingly, it's indicated as having an application period until 24th of June 2021, although most of the points which are in it are a very sensible set of ideas for the relationship generally. So it would be interesting to see why parties wouldn't continue to consider the code going forward forevermore. The code itself is not law, and we do have to look somewhere else for the changes in the law. And it's been one of the features of the pandemic is that the government makes an announcement or a press release, usually at one of their briefings, which itself is really only a statement of intent, and in most cases itself doesn't see any change in the law. So what we need to look for is where those changes in the law have occurred, and the code itself in its introduction text sets out what provisions and actions and announcements the government's made, but it doesn't itself cross-refer. Obviously, Charlotte has mentioned some of those, and I've tried my best to condense them onto one slide for the relevance and purposes of our discussion. So the primary legislation has been the Coronavirus Act, and I've just mentioned Section 82 relates to commercial property. That has also then required civil procedure rule amendments as to how existing court proceedings are being dealt with and how matters would be processed, and also changes in how the court has prioritized its diary and workload during the pandemic period, and that's still ongoing today. It's changing. More and more courts are being reopened, but they have changed those categories around. There's then secondary legislation in the form of the statutory instruments. We've had two of them for the enforcement agents, snazzily titled. I won't read them out, but they're all there. And then also a recently passed Corporate Insolvency and Governance Act, which have been much referred to as its terms when it was a bill, and in fact only recently got passed. But when mentioning the nature of government announcements, it is worth noting that the courts have acted based upon government press statements before any laws have been passed or practice directions changed. I mention this in passing because very early on in the coronavirus period, I was trying to simply get a warrant of possession for an outstanding matter issued and processed. And this was before any the Coronavirus Act had been passed or the practice direction put in place, but there have been government press statements that it was intending to try and protect and restrict these things. And I got my paperwork back from the court, simply rejected with a printout of the government press release. No reference to actually anything to do it, and they simply weren't going to process these things. Further, we had an unusual case which got reported, just referenced, called Re-A Company in 2020, and that's because the details are kept anonymized in the courts, whereby the High Court granted an injunction to an unnamed retail tenant to prevent its landlord from relying on a statutory demand that was served in April 2020 for rent and service charge arrears. And in an unusual case that the court granted the injunction because it was confident that the Corporate Insolvency and Governance Bill, which at that point was still being debated in Parliament, going between the Commons and the House of Lords in its normal format of a bill being debated and amended, but it was confident that the court was confident it would be passed and take retrospective effect. So we had this strange situation that a landlord proceeded in doing something which it was legitimately entitled to do by pursuing the statutory demand process at that time, pending any change in the law, and then a court enforcing it based on laws that are not yet being passed. As it happened, that bill was passed on the 26th of June, and it did bite against it, so probably the judge was right. But it's been a strange time for enforcements of these types of legislative changes. So as we'll see, these restrictions, I think it's important to highlight, are expected to be short term and currently run out at the end of September 2020. As Charlotte has mentioned, there is no change in law that says a tenant has a right not to pay rent, in the same way there is no legal right for them to demand a reduction. That would be a breach of the lease, and there are no changes which allow the tenant not to pay, but what it has done is introduce through this list of various legislation, rule changes, practice directions, curbs on the landlord's ability to take enforcement action. So by way of reminder, really, let's look at what the landlord's default enforcement options are. And I've just listed a few key ones there and helpfully added some nice red crosses to indicate the ones which are subject to restrictions that we are aware of at the present time. So running through them, obviously we've got forfeiture for non-payment of rent, and I stress it's for non-payment of rent. There are other forms of forfeiture still available in theory. Use of rent deposit already held, seek payment from a guarantor or a former tenant under an authorised guarantee agreement or guarantee. Fourthly, seek payment directly from a subtenant. Commercial rent arrears recovery, or CRA as we put there. Issue a statutory demand and pursue insolvency proceedings, and pursue a debt claim in the courts for unpaid rent. So I'll go through those briefly. I've just run through them very quickly to indicate where the changes have come in. So the provisions that we have, firstly for forfeiture of non-payment of rent, by way of reminder, what we mean as lawyers by forfeiture in simple terms is the landlord's right to end the lease immediately, take back possession of the property. This can be done by physical re-entry of the premises by peaceably changing the locks when the tenant isn't present, or more commonly by the issue of court proceedings. And there's usually a right to forfeit which has to arise in the lease once something's unpaid for 14 or 21 days. But you do have to check what the lease says and go through that procedure. So this has been substantially curtailed, and between 26th of March and now 30th of September, no new forfeiture action can be commenced by a landlord for non-payment of rent, and any existing proceedings have been stayed during this period. So this creates what's referred to effectively as a moratorium on forfeiture actions, and it covers both court proceedings and direct action. The wording in the text is by action or otherwise, so it's all captured. New practice direction was introduced by the courts, meaning that if you already had, for example, a warrant of possession or a writ of possession issued, and you were unlucky enough not to get it enforced just before this lockdown and legislation came in, that too has been stayed. So anything that relates to it effectively is curtailed until the 30th of September. Certain matters relating to forfeiture might still get dealt with before a court. For example, if there was an application to stay enforcement of any existing possession orders, injunctions or urgent applications that might arise might still get dealt with by the courts, but otherwise the court set out that its priority of work, understandably, was focused on more urgent matters and not on these types of matters. So effectively, forfeiture by a landlord for non-payment of rent is temporarily lost until 30th of September 2020. One point to mention is that of waiver of the landlord's right to forfeit, which has also been suspended. So ordinarily, lawyers, we'd be getting a bit worried at a landlord continuing to recognise the existence of the lease and demanding rent and taking actions which would otherwise recognise the lease as continuing, because that might risk them waiving the right to try and forfeit. So there is specific provision in to indicate that during this time, the landlord's waiver provision in these circumstances would not apply, and that seems entirely reasonable given the restrictions that are in place. So what about the September quarter rent? Because obviously March and June have been captured by these restrictions. You may have some tenants who have paid something towards their earlier quarters. It will remain to be seen what happens as we get to the end of September. Obviously, I think I spoke on this same topic, very similar topic, about 2 months ago when we weren't sure what would happen as we got near to the June quarter days. I suspect there'll be further reviews in August as the government takes a feel and the pulse of what's happening out there. So the next point is also to mention is tenants' relief from forfeiture, in that even if after 30th September a landlord did then get going with a forfeiture action, the likelihood is that a tenant would apply for relief from forfeiture to the court. And I should think that the courts would be sympathetic to any tenant's request for relief from forfeiture, given the exceptional circumstances of the pandemic. I mean, usually relief would only be granted in circumstances of payment, but it remains to be seen whether in due course we see some modified rules or legislation relating to that aspect, again by the government trying to enable tenants to continue in occupation and not lose it. So that's why I say it would be interesting to see what happens as we get to sort of August, September, as to whether these forfeiture provisions just come to an end or whether there's amended provisions and protections put in place. Use of rent deposit, again, this is identified in the code, and it's something which has come up in discussions with our clients as a potential option during this period, because there is normally, in many cases, a rent deposit sitting there, could be utilised as a temporary period to assist with both the landlord receiving some rent and reducing what's passing. So that still remains as an available enforcement option, subject to the wording of what's in the rent deposit deed or documents. Seeking payment from a former tenant or guarantor under an ARGA, again, that is an assessment of what opportunity there is to go after those individuals, and there's no change or restriction upon that process at the present time. Seeking payment from a subtenant who's occupying part of the property, again, you could well have a situation where the immediate tenant might be having some discussions and indicating it's got difficulty paying the head lease rent, but you might be aware, for example, there's a chemist or a retailer or someone that's open and trading as the subtenant who may be good for the money. So there's still the opportunity to serve notice and try and seek payment direct from a subtenant. And again, that avenue is still there. But again, it needs to be thought about and reviewed as to the merit of doing it. Commercial rent arrears recovery. This has been really played around with. As Charlotte mentioned, the amendment regulations number 1, which came in, initially prevented commercial rent arrears recovery taking place for a period of 90 days. And the number 2 amendment that just came in a couple of weeks ago has, on 19th of June, has extended that to the equivalent of 189 days rent. So just by way of reminder of what CRA is, it kind of replaced the old distress for rent laws. It allows a landlord to instruct a bailiff or enforcement agent to take control of tenants' goods at the premises which is subject to the lease, seize them, sell them, or do otherwise to try and cover rent arrears. There's a very specific notice procedure that goes through, which is all done by an authorised enforcement agent. There are some limits to it in relation to the fact that it can only be done at the leased premises, and there may not be goods or equipment of any value at that premises. So this has been curtailed. It comes under a few other points relating to enforcement and regulations relating to them for enforcement agents. Obviously, part of that related to simple health protection for enforcement agents during this time period. So that's gradually likely to change as we move forward. But again, there may be a trick here for tenants with the 189-day period. So unless there's the equivalent of 189 days rent in arrear, CRA can't be used. So I should think some tenants may be alert to this and potentially keep the rent arrears at a level which drops below that threshold to avoid that enforcement action. So we'll see. I mean, part of the issue has been during this period getting enforcement agents to go out and do anything. So that might, I'm expecting that to ease up a bit. There's some aspects of the enforcement process which are already indicated will be eased in August. So watch this space. Issuing a statutory demand, as Charlotte's referred to, and I've mentioned by reference to that case already of the odd injunction. It was the case that this was being utilised by some landlords early on in the lockdown process since 26th of March, and so much so that it signalled some alarm bells to the government, who swung into action by the 23rd of April, indicating it was going to restrict it. They put those restrictions in the Corporate Insolvency and Governance Act, and that then spent the best part of 2 to 3 months going through Parliament. But it basically imposes a temporary ban on the use of statutory demands between 1st of March and 30th of September, and winding up petitions between 27th of April and the 30th of September, where the company cannot pay its bill due to coronavirus. And more details of this will come out in due course, but it does seem to offer a somewhat vast protection in circumstances where the threshold relates to whether they've been impacted by coronavirus. The final point I put on is issue of court proceedings for a debt claim. This seems to be really the only thing that is readily available and still ongoing. You can't issue proceedings to try and do forfeiture, but if the rent is still due, it is a debt. It's a contractually agreed debt by reason of the lease. It can include a claim for interest and costs. And so there's still the ability to issue county court and high court actions for sums which are due. Now, obviously, the process can become more expensive and protracted if defences are put in, although it's difficult to see that the tenants have many defences to contractually agreed payments. And if defended, it may be that a court hearing would not be seen before a court for several months, and there may not be much impetus for a tenant to pay arrears during this period. But the landlord might seek security that a county court judgment has. It might give the tenant time to get its financial affairs in order and pay arrears and preserve the landlord and tenant relationship. And it certainly seems an appropriate way of taking action to obtain unpaid rent. Certainly our experience in 2008-2009 recession was landlords were prepared to pursue debt claims for the rent and obtain a judgment and then look at other enforcement options. And of course, the advantage of other enforcement options is if, for example, the premises that you've got with a tenant in doesn't have anything of any real value in it, but you know other premises does, then you've got the ability to enforce that judgment by other means and at other locations. There's also 6-year limitation generally for rent arrears, and so there is some time period for deciding what to do. Therefore, really, sort of before I end, is considering, well, what happens after 30th September? What do we think we're going to see by way of administration and tenant insolvencies, the problems of trying to prove that coronavirus has not had a financial effect on company, backlogs, and when will actions recommence? In summary, really, the enforcement options have been severely limited to the landlords regarding forfeiture, CRA, statutory demands, and insolvency proceedings. Of course, it hasn't stopped some tenants recognising that regardless of these protections, the numbers don't stack up and go into administration. We've already seen some high-profile ones of those, and I fear and suspect that we will see many more in the months to come. And then that then is just a matter for parties to deal with the administrators or liquidators, as the case may be, to try and resolve what happens with the premises. The point regarding coronavirus having financial impact on a company, as this is actually part of the legislation that has changed. And it's quite a difficult test for someone to try and overcome. If you're the creditor of a company, to overcome the moratorium on a winding up petition, you would have to demonstrate that the coronavirus has not had a financial effect on a company. Now, no real information is available, and I'm not an insolvency lawyer, but looking at it, that's a really difficult test for someone to overcome, because how would you know how the internal workings of a tenant company might work, how it could have been possibly impacted by way of its trading, its staff, its customers, suppliers, any sort of effect which would reflect on its finances. Even simply a delayed payment process would clearly have an effect. So it's almost a blanket moratorium there. Court backlog of cases, of course, I have to mention this because quite simply, there was already a delay with courts of a couple of months on many things. We can just see these things are going to build up, and if get-go happens in September, then it will add further time. And as I said before, when will bailiffs restart? Could be some work in August, and see where it goes from there. So there we have it, a rather whistle-stop tour of landlord enforcement options during the COVID-19 restrictions. I hope it's been a helpful summary of the options and where the law has changed on matters. And perhaps if I can hand back control seamlessly to Colin, then we can have a look at some questions. Thank you very much.
That's right. Thank you for that, James. Thank you for that, Charlotte. And thank you to everyone who's obviously come along and listened today. We're at the point of today's session where we are at the ask away any questions that you may have point in time. So as we said at the beginning, there will be a question mark symbol of some description somewhere on whatever device you're using. If you do have questions, then now is your opportunity / time to please type them in, and we'll try and deal with them if we can. If we don't get any, then I'll assume we've covered everything to everyone's absolute satisfaction. First question in, and I know James and Charlotte can also see these. So what sort of terms has Charlotte, so I guess we know who's answering this one, has Charlotte been able to agree with tenants in terms of re-gearing leases? I suspect you can't necessarily give away too much of the detail of that, but have you been able to agree terms to re-gear leases?
Yeah, I think where there is a mutual benefit to to both parties in re-gearing a lease, then we have seen that happen, and in particular where you have a tenant who has a viable business. I mean, we've had question marks over, do you give concessions to tenants where their business isn't viable long term anyway? If you're going to give them 2, 3, 4 months rent free even, and then it still doesn't survive, well, have you just thrown money down the drain? So, that is part of the code. It's about looking at the long term, sustainability of that business. And, if they do have a long term future there, and in particular, if they are a strong covenant, they are, a good tenant to have in your property who has largely paid their rent on time and will be there for the foreseeable future, then landlords are in that case interested in keeping them longer term, and will probably be more keen to strike a deal and agree a concession in the short term. So we have seen, as they particularly stronger covenants manage to agree short rent concessions. So we're talking probably only a month to 3 months rent free at the very, very best. But in return for, in some cases, relinquishing break clauses, which are sort of coming up in the next 12 months, or to extending their lease by 6 months to a year, 3 years in some cases, or negotiating early surrenders and taking new leases now, or reversionary leases which start at the end of the existing term. So that's obviously been a benefit to the landlord. They've tied the tenant in for a longer term. They've they think the business will be there, in the longer term, in particular, and the tenant obviously has, a small concession to help them through the crisis in the meantime. So yeah, we have seen that. It's not I say widespread, but there's certainly a number of cases that have been agreed. So yeah.
And I think one of the points you were making earlier in the session is, if you're in a tenant's shoes and you're in difficulties, don't necessarily leave it to the last minute to go and talk to your landlord about it, because what you might actually be doing is limiting the options you've got for that very discussion, because you'll have put your landlord actually in a situation where then they've got restrictions on what they've got the flexibility to do for you.
Yeah, there's two angles to that really. I mean, the first point is that, you know, if you just avoid the situation and bury your head in the sand and you know, ignore any sort of requests for communication with your landlord, then it's just going to frustrate the situation. And we have seen that landlords have been much more inclined to agree concessions and support tenants where they've been forthcoming and they've, you know, wanted to talk to their landlord about the issues and been transparent about, you know, what's happening in their business. You know, landlords have been much more supportive in that case, whereas they've been, you know, frustrated by tenants that haven't come to the table. And I think, you know, in some cases these landlords, you know, have been less inclined to support the tenant in return. But there's also the other aspect that, you know, these restrictions are temporary. As James has quite rightly said, they will be reviewed and potentially they will be extended, but I can't see that they will be extended indefinitely, and I certainly don't see them ever superseding, you know, the contractual agreement between landlord and tenant. They're not going to, you know, alter that. So ultimately, longer term, these tenants are just creating more of an issue for themselves because they've got those protections in place at the moment. So now is the time to come to the table and try to strike a deal. The longer they leave it, the more chance the restrictions will be lifted, and they won't be in such a strong negotiating position. Not to mention, you know, they could potentially face eviction or other sanctions. So it is crucial that, you know, they come to the table now, they try to agree, you know, a deal that suits both them and the landlord, you know, while there's still time. And you know, not to mention they're also building up arrears in the meantime. I mean, the rent is due every month or every quarter, depending on how it's agreed in the lease, and every month or quarter that passes, the arrears are just building up. So if they can reach an agreement to pay them in instalments, even if they're small instalments, then they are making inroads into paying them off because they will be due at some point.
Thank you. One of the other questions we've got is, and this is a bit of a tricky one, it comes back to some of this imbalance I think there is a sense of between landlords and tenants in all of this, which is, you know, how open are tenants being with their landlords if they're saying they're in financial difficulties? I think this also overlaps with one of James's points about the new winding up provisions and, you know, oh yeah, we've got coronavirus issues. Well, everyone could say that. To what degree would you have to prove it? But in effect, are landlords sort of asking tenants to prove they're in the financial difficulties they say they are?
Do you want me to answer?
I've from a practical point of view, I suppose, for you, Charlotte. From a legal point of view, James, how much you actually demand they prove they're in difficulties? Yeah.
Well, I was going to say, I mean, sorry, jumped straight in over Charlotte there. I was going to say, from the legal point of view, if someone reads what is in the restrictions, you would wonder why a tenant would want to share any of that detailed financial information if there was a risk of doing so might offer the landlord the ability to say, well, actually, I've scrutinised your figures, and actually, I don't think you've been adversely financially impacted by the coronavirus pandemic, because look at all that money that just came in from another source. So I suspect there will be a lack of inclination to share too much detailed information, but I think it, you know, the code envisages, doesn't it, the parties being reasonable and trying to share and you know, be as transparent as they can. But I can see that in many respects there's a disincentive there, because a tenant might just open itself up to something. But Charlotte, your take.
Yeah, I think, yeah, you've made a good point, James, because, you know, largely we've seen very, very few tenants, you know, being transparent with their finances. And I think what we have asked them in most cases where they've requested a concession or, you know, some kind of support, we have, you know, said, well, can you demonstrate that you really need it, because, you know, it will help us make a case to your landlord. And in most cases, you know, that information hasn't been forthcoming. And I think, you know, it's very easy for businesses to say, well, I have been impacted by a coronavirus. If I'm honest, most businesses probably have. Their turnover probably has reduced in some way, certainly the retail premises that we manage, and even, in some cases, industrial and office sectors as well. But the point is, has their sort of bottom line been affected to such an extent that they can't meet their rental obligations? Because we all know that there's been support from the government. We know that some of the larger tenants are quite well capitalised. So, whilst they may have seen a reduction in their turnover, they have also benefited from support. That might not be sufficient in some cases, but in a large, number of cases, it is sufficient. And in particular, with a lot of our smaller tenants, we know that they've received grants of £10,000 or £25,000, and actually they have been quite honest about that in most cases. And in the majority of cases, they've used it to pay their rent, because for small shop premises, the rent isn't always £10,000 for the whole year. So if you've received £10,000 in your bank, and your rent is only a couple of thousand of that, then one would hope that that will see you through, at least until you can reopen and start generating some income again. But yeah, most tenants haven't shared that information, but most landlords have still been willing to support them on the basis that it's quite obvious they have been affected, just perhaps not to the extent that some tenants are letting on.
Not quite as much as some might be portraying, yeah. There are some technical ones coming in that are probably more James, but if you can't answer them, James, tell me, because I don't know how complicated these questions are, because I'm an employment lawyer for a day job. So some of this language makes no sense to me. But is forfeiture or refusal to renew available to a landlord where a Section 25 notice is about to expire and they're not paying the rent and not committing to renew?
It's quite a lot in that.
Is there?
I
Sounds
guess
very simple to me.
Yeah, of course it does. Yeah, there's possibly lots of permutations on it, but I guess the key point to answer on that is the restrictions on forfeiture, which I've outlined, all relate to non-payment of rent. This is what the restrictions apply to. So forfeiture is still available in theory. I say that because of enforcement options, but forfeiture is still available, for example, for other user covenant breaches or repairing breaches or other breaches of the lease, in the same way that if a lease or fixed term tenancy were coming to an end and the tenant lost its rights, didn't in this particular situation as Section 25, but if the tenant didn't do anything, didn't protect, didn't extend, didn't issue court proceedings such that it lost its statutory rights, and then it's just holding over in the premises, that is not covered by the moratorium, because that is not forfeiture for non-payment of rent. So provided you're doing it for other reasons and it's effectively the end of the lease or statutory protection rights lost, then it should still be possible to terminate. So it's slightly different, I suppose, if the tenant does take action to issue proceedings and protect its position or otherwise, then you're just basically into renewal proceedings. And again, I suspect the courts, in my experience, were already, as I say, in some instances running 6 to 8 weeks behind on processing paperwork as we were going into lockdown. So a canny tenant might issue protective renewal proceedings, delay service, and drag it out through the courts. So that's why there's a few different layers to that. But key point I want just, I suppose, to clarify on answering that is forfeiture is available if it is for other things, not just rent.
Cool. Thank you for that. The next one is, and again, terminology I don't understand, but hopefully Charlotte will. What are the likely implications for ERVs and yield expectations in the next 12 months? I don't know if that's something you can answer or whether that makes no sense at all to you.
Yeah, it does, just about. Whether I've got the answer though is another question. ERVs, so estimated rental value, although I think that term is now been replaced with MR, which is market rent. Anyway, market rents, yeah. I mean, in particular in the high street retail sector, they're probably going to take a hit. In fact, I very luckily, based on the fact this question has come up, I saw a report this morning from the RICS which suggests that high street retail will probably be down somewhere in the region of 12% year on year. So that is probably going to take the hardest hit. But other sectors probably haven't escaped either. I mean, offices in particular, they were doing reasonably well before, lockdown or before coronavirus. But, we're now all reassessing how much office space we need, and in what shape or form, and potentially, they won't escape, the effects of it either. The industrial sector, I think, probably will see some growth still. I mean, in particular logistics and distribution, we're well aware of the effects of online retailing over the lockdown period. I mean, that is just going to probably grow and grow, and it's it will have an impact on demand for storage space and distribution hubs. So the likes of Amazon, etc., will drive that. But as for smaller retailers as well, or online retailers. So I think industrial probably is going to outperform the other sectors in that respect, in terms of rental growth, and yields will just follow that trend. I mean, retail high street has been, a bit unfashionable for a couple of years anyway. Some reports have just suggested that this has just, accelerated that downward trend. Because there was always concerns that retailers were struggling anyway, high street retailers, and moving more online. I mean, we've seen obviously the likes of Laura Ashley and various companies like Cath Kidston go into administration. Some of those companies they'll continue trading, but they'll just move purely to an online presence. So we will see a lot more voids on the high street, sadly. But that all links in, much more widely with changes and reforms to the planning system. So again, there's been announcements made that, the government intend to relax, changes to planning law, which link into commercial properties and how you can, hopefully, use them more flexibly for other uses, so residential perhaps. And fingers crossed, we won't just end up with sort of ghost towns. We'll just see more of a change towards other uses instead. But hopefully that answers the question.
Great, thank you. Thank you for that. I'm conscious of the time, so thank you for those of you that stayed with us. I hope it's been of use. For those of you who are asking James to give us a tune on the piano, I think that might have to wait for another day, but thank you for the suggestion. We have asked many times. We are yet to see him actually play it. We're yet to find out whether it's actually a real piano or whether it's just an ornament that makes him look sophisticated. We're not entirely sure yet, but one day we might have to give that a try. But thank you in all seriousness for coming today. If you do obviously have any queries or any issues, then James's and Charlotte's details will be on the slides that we will be sharing with you afterwards. Otherwise, thank you for attending, and I hope you have a good rest of your day.
Thank you very much, everyone.
Thank you.